We hear the term renovations often, where a tenant is evicted for renovations and then the unit lands up being re-rented for a much higher rate. Now, of course, landlords do have the right to renovate, but the Rental Tenancies Act lays out a process that must be followed that also builds in some protections for tenants.
It starts with an N13. So your landlord can't just send you a text message. They have to use the N13 form. And that form specifically sets out the grounds for the termination. So whether it's a demolition, whether it's a renovation, whether it's a conversion.
Renovations have to be so extensive that they require a building permit and vacant possession, meaning the unit needs to be empty.
For example, if all the wiring in the building needs to be updated or all the plumbing needs to be updated in the entire unit, and within the N13 there will be a termination date, and that termination date has to be a minimum of 120 days ending at the end of the rental period.
The tenant can choose to leave by that date or leave early by giving 10 days notice. If they disagree with the eviction, they can choose to wait for a hearing at the Landlord-Tenant Board. The tenant is also owed compensation.
Whether it be financial compensation, or the landlord can offer the tenant another acceptable unit.
What does right of first refusal mean?
So it's essentially the right to move back into the unit when the repairs are completed, and it would be on the same terms of the original lease and the same rent.
That does not apply if the unit is being demolished or modified so much that it no longer exists as an independent dwelling. Right of first refusal must be invoked in writing before the tenant moves out, and contact information should be kept up to date with the landlord. The landlord, in turn, is responsible for informing the tenant when the renovation is complete.
However, a lot of landlords want to capitalize on the high market rents and re-rent the unit to somebody else at a much higher rent. And this is where we start seeing bad faith evictions, and that's where the term rent-evicted comes from.
If the tenant feels that they were evicted in bad faith, for example, if the renovation wasn't extensive, the right of first refusal wasn't honored, or renovations weren't done at all, they have some recourse with the LTB.
They can file a T5 application and go to the board to explain why they believe they were evicted illegally. And they can also ask for different forms of compensation, whether it be financial, for fines. One thing they can do is to say, I want to be reinstated as the lawful tenant back into that unit, even though there's an occupant in there.
Now, there are certain special circumstances under which a tenant can be granted not just a delay, but a relief from eviction. For more on that, you can go to our website, citynews.ca. For City News, I'm Dilshad Burman.